our co-chair of Indirect Tax Committee, Sri Advocate Chartered Accountant, Mr. Prabhan Arora ji. He is a Chartered Accountant and a law graduate by profession, associated with Athena Law Associates since 2010, and currently head of the GST advisory services of the firm. So I request to Pawan Arora ji, please start your presentation and all the participants.
Thank you, Nandaji, for the brief introduction. So, good evening, participants. Now, after discussion on the all budgets amendments, my topic was GST amendments regarding the returns of GST and the registration. The first most change which have been made, although it has not been implemented till the date of in last 4 years, but now finally government has realized that it is no more required. You must have heard about section 42 and 43, which is about two-way communication of the ITC. So when the GST was introduced in 2017, we all must know that when we are implementing GST, and I also remembered my days when I was showing the chart to my clients that, okay, you are supposed to do this all chain communication with your recipient and the suppliers, that he will upload the ITC details on GSTR 1, that will be reflected in your 2A or 2, you can amend it, that will come to in your 2A, and then that will show in 1A of the recipient supplier, and again he has the facility to amend, and all these long process has been defined initially under section 42, 43 and their respective rules. And from that only, and from that section 42 and 43 only, this matching concept has been arisen in the minds of the tax department and the tax assessee. Otherwise, there was no as such matching concept was mentioned in any of the provisions. So the matching word has come into our mind only through section 42 and 43. But what happened? Section 42 and 43 has to be governed through GSTR 2 and the GST communication of GSTR 2A into 1A and 2A and the 3. So, but since GSTR 2 and GSTR 3 have never been implemented on the GSTN portal, so these two provisions remain ineffective, section 42 and 43. But unfortunately, since the government have given one facility of 2A to the taxpayers, the department took a view that yes, you are supposed to do matching. They forget that matching was required under section 42, 43 through GSTR 2 and 3, which was not into effect. Then where is the concept of matching was there in the law? But unfortunately, we all still, despite many changes in the law, which I will discuss, we are receiving the notices from the department that your credit is not matching in 3B and 2A during the financial year 17-18, during the financial year 18-19. So you may kindly reverse it. And in fact, at some places, we are not getting ASMT 10. We are not getting pre-show cause notice in GSTR 1, DRC 01A. We are directly receiving show cause notice. You can imagine that show cause notice is one mode of litigation when it is initiated. So we are getting show cause notices on that point also. But the point has been acknowledged by the department in the case of Bharti Airtel before the Honorable Delhi High Court that yes, GSTR 2 and GSTR 3 is not into effect. Therefore, section 42 and 43 is also not into effect. So my friends, because of this, section 42 and 43 was not into effect. The matching was not required at all under the law, especially during the year 17-18, 18-19, and up to 9 October 2019. I will discuss the second period. First, I am limiting myself on the up to 9 October 2019. There was no matching provision required. So you can simply get set aside your notices on this ground. Secondly, if you are observing the law development in 2018, approximately near just 3 days before Diwali in October 2018, they come up with a press release that GSTR 2A, the credit reflecting in GSTR 2A is mere a facilitation for the recipients, and this will not impact the eligibility of ITC. Despite this press release, the notices are coming. So the government have now recognized this issue and they have removed this section 42 and 43. But what about the past notices? We can argue very well that during the 17, 18, 18, 19 and up to 9 October 2019, there was no matching provision required. GS 42, 43 is not into effect. Therefore, you can't challenge my ITC merely on the ground that my ITC is not matched with my 2A. Now coming to the second part, you may say that, okay, as Mr. Shivam has discussed that from 9 October, rule has came, but it have no legal sanctity. What it mean? On 9th October 2019, they come up with a rule 36.4 in which they have given that you can avail the credit up to 120, 110, 15% of your 2A credit. And it is still effective till date. But it has again been challenged. Why so? Because you must have observed that section 16 is the main section which allows you the credit. By satisfying the 4 conditions earlier, it nowhere permit the government to restrict the credit by putting a condition through a rules in such a manner that if credit is not matching, then you can't avail the credit. But beyond the power given under the section 16, they have put up a rule 36.4 in which they said that you can't avail the credit if it is not reflecting in your 2A. So it has been challenged, and we hope so that court will definitely held that section 36.4 is beyond the section 16. Now the government, I heard one government seminar in which they say that section 43A was there. Now, if in this budget, section 43A has also been omitted, they took a view that section 43A is there, which is giving legal sanctity to 36.4. My submission to that is that section 43A, if you read it carefully now, but it is omitted in this budget, section 43A says that government may prescribe the procedure to avail the credit. It nowhere empowers the government to make a rule to restrict the credit. It only empowers the government to prescribe the procedure to avail the credit. So therefore, 43A is also not giving any sort of power to the government to make a rule by restricting the credit if the credit is not reflecting in GSTR 2A. It can only empowers though that to define the procedure. So therefore, section 43A is also not given any sort of legal backing to the rule 36.4. And now this 42, 43 and 43, 42 and 43 has been amended, and 43A has been omitted. Now, with effect from 1st January to 2022, which Bimal sir have also discussed, Shivam has also discussed that 16(2)AA has been inserted, which provides that now if the credit is not reflecting in your GSTR 2A, then you can't avail the credit. From 1st January 2022, the government recognized their problem that Rule 36A doesn't have any legal backing. They introduced a legal provision to restrict that credit. So prior to that, there was no law. You can very well argue that case. Now, as Mr. Shivam Mehta has said, that 16(2)AA is still subject to challenge on the ground, that how can you impose this type of restriction on me to match this credit? Totally acceptable this, we can challenge. But one of my client has asked me question, sir, we were following that there is no restriction under the law and we are claiming the credit. But can we continue with that stand even after 1st January 2022 when the credit has been restricted through a law? So my answer to them is, listen, now the major arguments which we were arguing in the past that there was no law has been now taken care. They have put this restriction under the law. Now this question is only of a challenge the validity of that section. that whether can they do so by imposing this restriction under the law. Now, since the question came up on the legality of that section, that whether government can do so by imposing such type of harsh restriction on me. So the answer is you must follow that until unless it is held to be any arbitrary condition under the section. So with effect from 1st January 2022, you must follow that condition until unless any court held it to be arbitrary in the law. Prior to 1st January 2022, Rule 36(4) doesn't have a legal backing, you can argue. And prior to 9 October 2019, you can challenge it because there was no provision, no rule at all under the law. So this amendment was basically when the two-way communication has been done away in this Finance Act 2022 by amending the section 42, by amending the section 43, and by omitting the section 43A. Now coming to the second amendment, which Mr. Shivam Mehta has also touched upon, the time limit to avail the credit. Although Mr. Shivam Mehta has given the interpretation of the law that now you can claim the credit in the October month return, which you can file up to 30th November, is the interpretation of law. The same interpretation has been given by the department in very recent presentation, in which we are also part of that presentation. But my another angle on this point is, and considering the fight which is coming from day one, that section 16(4) provides the time limit to avail the credit, and my books of accounts is a statutory record as per section 35. So if that is a statutory record, at section 16 nowhere provides that credit has to be availed only in the return. The credit, if availed in the books within the time limit prescribed under section 16(4), then why I should be denied the credit if I filed a return by delay? My interpretation to that is, if I avail the credit by 30th November in my books of accounts, followed by filing of return of November into the department, I must be allowed the credit, because section 16(4) nowhere provides that you can only claim the credit through GST or 3B. The time limit applies equally if I claim the credit in my books of accounts also. So again, this is a fight which may be going in some courts also. So, but yes, the interpretation which have been given by Mr. Shivam Mehta, that the department's view, which they have also expressed, that you must avail the credit in the October's return, and you have been allowed 10 more days to file the delayed return. So if you file the October return beyond the 30th November, then your credit get lapsed. So this is the interpretation of the department. Yes, we should follow that to avoid any sort of litigation. But if you for any reason not able to avail that credit within that time limit, then yes, there is chances to argue that on this point, that the credit availed in the books within that prescribed time period, filed in the respective returns, although filed with a delay, we must be allowed the credit. Second, on this part also, time limit to avail the credit, which Ms. Kanupriya was also discussing. My one point is that there is one gray area. I want to highlight one gray area, although my view is clear on that, but there is a gray area on the point, that availing the credit, reversing the credit, and re-availing the credit is only permissible under the law in case of non-payment to the supplier. So if I do not pay to the supplier within 180 days, and if I repay it to the supplier, then I can re-avail the credit. First, I have to reverse the credit with interest, then I have to re-avail the credit once I do the payment. Apart from this situation, there is no mentioning in the law that for whatever reason, like Mr. Bimal sir is also discussing, Mr. Shivam Mehta is also discussing, there are so many reasons now introduced that I supposed to reverse the credit. Now, section 41 is also mandating me to reverse the credit if my supplier has not paid the tax. So there is multiple reasons given to me to reverse my credit. Firstly, I avail the credit within the time limit, but for XYZ reasons, I supposed to reverse my credit. Can I re-avail it with beyond the time limit? The law is silent. The law is silent, therefore it's a gray area. But there is a judgment in the service tax regime and central excise regime that the similar time limitation was provided in that 6 months from the invoice date. Then the court said this time limit of 6 months to avail the credit is only for originally availed credit. It is not for the re-availment of credit. Once originally you avail the credit within the time limit, then of course the re-availment is not subject to any limitation. So this again, the gray area which is subject to scrutiny of the judiciary, but definitely my view is on that re-availment should not have any limitation under section 16(4). The similar time limit has been extended for the issuance of credit note. So a credit note can be issued up to 30th November. Similarly, earlier it was up to the due date of September returns. So again, the point on the credit note is that this limitation, people get confused that I cannot issue the credit note at all beyond that point of limit is not the point. You can issue the commercial credit note any point of time without any tax adjustment. This time limitation is applicable only to take the adjustment, to take the benefit from the government of issuing the credit note. So if you are not able to issue the credit note in that, you can issue the commercial credit note. And if your recipient is eligible for full credit, but of course he is not supposed to reverse the credit, and the point is revenue neutral, and you not get any loss if the recipient is eligible to credit of the ITC which he has availed originally on the invoice. Now coming to third part, you must have heard that in this Finance Act 2022, the time limit to avail GSTR 1 to revise GSTR 1 and GSTR 3B has also been extended up to 30th November. So multiple time limitations have been extended up to 30th November. When I prepared this update of budget, one of my participant has asked me question, sir, there is no time limit, there is no concept of revision of GSTR 3B. Why you are saying that GSTR 3B can be revised up to 30th November or today up to 30th September? So my friends, there is a provision under the section 39 that GSTR 3B can be revised, can be amended up to the due date of September, and now up to 30th November from this amendment to be effective. So what it means? You must aware about a circular given in 2017. It's number I think 7717 or 171717, which says that if you found any mistake in your 3B return, you can amend it through your subsequent month's GSTR 3B. So if you have paid any extra tax, you can take adjustment in your subsequent GSTR 3B. If you have paid any less tax or less avail credit, so you can amend it through your subsequent by rectifying your subsequent GSTR 3B. So it's not like GSTR 1 which you can rectify the previous month's data. It can be done through GSTR 3B of the subsequent month. So yes, there is a mechanism available given under the law that GSTR 3B can be amended through a subsequent month's return. Although in one of the case before the Honorable Delhi High Court in Mrs. Anil Goyal, it has been pointed out that despite the fact that law provides for the amendment in the GSTR 3B, there is no mechanism given under to revise my GSTR 3B. But what they said that you can amend the subsequent month GSTR 3B. Coming to the fourth point, which I have to cover, although Mr. Gaurav Gupta has covered this point that cash ledger, you can transfer the cash ledger to different GSTIN. But my point is, what my expectation was is, it is very welcome amendment that you can transfer cash amount to a different GSTIN, but still there is a mechanism available for the refund of that amount. But what was the exact loss happening in this because of this structure of the GST from 2017 is that I have tried to open my one of the branch in different state, and that branch was not successful. I want to close that branch. My credit was lying there. So I am not able to take refund of that credit in that state, and I'm not able to transfer that credit to my working state. So this was also a bigger issue which needs to be taken care by the government. But I expected that they will come up with this amendment that you can also transfer the credit, but they have not come. I come to analyze this position once. Then I thought upon that. Can we say that my one branch is closed that have been merged into the different state? Like I have opened a branch in Mumbai, and my Mumbai branch has been closed, and now that operations will be taken care by the Delhi branch. Can I say that that has been merged into Delhi branch? So it is difficult to say. And it is also not supported by GSTN portal. Why I'll try to transfer the credit, because it is only allowing me transfer credit through ITC 02 to the same state. So this problem should be taken care that credit accumulated in my one of state, if I close that state and started to do that operations in my another state, my credit should be allowed to be transferred, like they allowed me to transfer the cash ledger balance. The second amendment which they have done in section 49 is they have given the legal sanctity to rule 86B. What this rule 86B says about that, to accept to certain assessees, they allowing me to use the credit up to 99%. So they are saying that you have to pay tax 1% from cash. So this there was some exception. Apart from that exception, assessee, everyone has to follow that they have to pay tax 1% through cash ledger. So again, there was a fight that rule 86B doesn't have any legal backing. So to that, they have amended section 49 to give that legal backing to that section. Now coming to my second last amendment which I have to discuss is cancellation of registration. Now you must be aware that because if credit is not reflecting in my 2A, credit is not allowed to me. So what recipients are doing, they are putting a restriction on the suppliers that if my credit is not reflecting in my 2A, then I will not give you the GST amount. Then to take care of this situation, what the supplier are doing, they are filing the GSTR 1, but they are not filing GSTR 3B. And they are filing the GSTR 1 continuously. And because they are filing the GSTR 1, the details are getting reflecting in 2A, and recipient is taking credit and paying the money to them. But unfortunately, some taxpayers either not paying the tax by mentioning the less amount in GSTR 3B, or either not filing the GSTR 3B. Now this has been, if the return is not filed, then the registration can be cancelled. It is earlier also, there was a law that if for past 6 months you will not file, your registration will be suspended and cancelled. Now by doing this, if the registration has been cancelled, then they will not be able to file the returns, even GSTR 1 also, and that problem get resolved. But what about the past? I seen many notices, handled many notices where the notice mentioned that GST registration of your supplier has been cancelled. Then I am not allowing you the credit. I astonished that why you are denying credit just because you have cancelled the registration of my supplier. So one reason they are giving, they have not, it is assumed, not a proper reason, but they are saying it is assumed that they have not paid the tax. So what is happening today, that department suo moto cancelling the registration of some persons from day 1, 1st July 2017. So you must check the status of cancellation of registration from when it is cancelled. It is suo moto or from the application. Second round which I took was for cancellation of registration, the supplier have filed application to you. Have you asked me before cancelling the registration that shall I cancel the registration and deny the credit to you? You yourself permitting to cancel the registration of that supplier before without ensuring that he has paid the past excess, and now today you are denying the credit to me. So this problems is coming today, that since the registration has been cancelled, we will not allow the credit. Is to be handled properly through a legal arguments. Now, the last point is they are coming with an amendment that if the GSTR 1 is of previous period is not filed, we will not allow you the GSTR 1 of this month. If GSTR 3B is not filed of a previous period, then GSTR 1 is not filed of previous period, then GSTR 3B can also not be filed. So this is again a welcome amendment, because again that issue is coming that people are filing 1 and not filing 3B. So we are getting problem being a recipient that by assuming that he has uploaded the detail and coming to my 2A, I can avail the credit. But connecting with this issue that they are not allowing me the filing of return of GSTR 3B and GSTR 1. And the point section 38 in the first 3 presentation discussed by Bimal sir, my point which I've raised with the department also during our last discussion with them, I said, sir, you are saying that if the supplier will not follow section 49, that if he is paying tax for more than 99% in credit, or if he is availing the credit reflecting in his 2A, 2B more than he is availing the credit, then you will not allowing me to avail the credit. I said, sir, why you can't stop the supplier to file his return rather than denying the credit to me? The answer was, we just introduced this section 38. We are making the rules of that. We will implement in a staggered manner, not all provisions together, but this is not their official statement. But the point is, the time will tell how this Decorian section 38 will be introduced, how they will be able to draft the rules. And as Mr. Shivam Mehta said, it is very strange to see that whether government portals will be able to give such accurate reports that they will decide my credit is allowed or not. So with that, I end my presentation. Thanks to all of you. Over to you, Nandal.